All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in 1 CV21 0055, Chalmers versus East Valey Fiduciary et al. Counsel, we've read the briefs. We've conferenced the matter in conference this morning. Both sides are given 20 minutes for their presentation. Please announce the party that you represent prior to your remarks. With that, Mr. Cook.
Thank you, Your Honor. May it please the Court, my name is Alan Cook. I represent Mr. Chalmers and, as it happens, because of the sanctions order, myself on this appeal. And I think that I have laid out the facts pretty clearly in my opening brief. And what's happened here basically is Mr. Chalmers was not being cooperative enough, I guess, his lawyer, Mr. Keller's, thought in his divorce, so he referred him for an assessment about whether or not he needed a conservatorship or guardianship. And Mr. Toit was appointed to investigate that. And Mr. Toit hired Dr. Levitt to do an assessment. She is a psychiatrist who says she also does forensic psychiatry, in which I guess that's what this would be. And thereafter, the entire record was made by court-appointed people. It was made by Mr. Toit, the guardian ad litem, who this court has already said has absolute immunity from everything he did, which is certainly a disappointment, but there it is. But that's why he's not part of this appeal and why we want him separate. They appointed a Mr. Doyle. Mike and Gary Doyle actually teamed up their brothers with the same firm to be Mr. Chalmers' court-appointed counsel. They appointed, well, at Mr. Toit's choice, East Valey Fiduciary Services, which is how Mr. Sharber got involved. He was their lawyer, and proceeded apace. In early October, in an opinion written October 13th of 2017, when this probate case, the underlying probate case, was only 2 months old, Dr. Philip Berry opined that Mr. Chalmers did not need either a guardian or a conservator, temporarily or otherwise. It's my understanding, as we've alleged in our papers, that Amy Moody, the court-appointed investigator, met with Mr. Chalmers and did a report, and her name or the reference to the court investigator shows up in the Rule 33 applications and things, so there's no issue here, I don't think there is, about the fact that she was appointed and that she did meet. And it's Mr. Chalmers' understanding that she did a report in which she also recommended he didn't need a guardian or a conservator, but that report is not in the court's file. And Mr. Chalmers...
Cook, yes, Your Honor. If I could direct you, I'd like to... The way I understand it, Judge Duncan dismissed, and I'm going to refer to it as your civil action.
Thank you.
Judge Duncan dismissed your civil action based on the doctrine of abatement. Am I right on that?
Well, I don't think it's that clear, but yes, that was one of the things that was mentioned. That's correct.
Okay, so if we accept that as true, the way I understand how abatement works is a second or subsequent cause of action is dismissed if the claims within that action are present in a previous action. And the way I understand Judge Duncan's ruling, and again, this is what I'm asking you to correct me if I'm wrong,
sure,
is Judge Duncan said every single claim you have raised in this petition was raised in what I will refer to as the family action or the probate action. So by abatement, those claims need to be addressed in those actions and not this action.
I agree that that's the essence of everything that she said in the third judgment that she entered in this case.
Okay. So with that in mind, can you direct us
Yes.
to what claim,
Sure.
what specific claim you raised in this civil action that was not addressed in either the probate action or the family action?
Yes, Your Honor. And they're set out at page 15 and 16 and 17 of the 18 of the opening brief.
I know they were, but it seems to me like many of those were addressed in previous actions. And so if you could just tell me,
I will, Your Honor.
this claim was raised.
Number one, Your Honor, there were no tort claims raised in the family law case or in the probate case. No tort claims.
Were the tort claims based on claims that were raised in those actions?
Not in the actions that led to the appeal, and some aspects of them were addressed, but not the claims themselves for breach of fiduciary duty. That was not raised. The tort claims were not raised, and with respect to the underlying issues, in one of the other appeals related to this, the Court of Appeals has reversed the trial court's decision, refusing to look at attorney's fees awards of some $230,000 that the trial court made to these defendants and some others. And I understand there's oral arguments set on that issue that's been briefed in the Superior Court and before Judge Marquardt, and they heard that there's an oral argument set, but I mean, I'm not representing Mr. Chalmers in that proceeding.
And that was the remand from Judge Cruz's memorandum decision from this court, correct?
That's correct.
Okay, now in that action, since it is an action and that claim you said is being addressed, then that can't be the basis for this one under abatement,
I
right?
disagree with you, Your Honor.
Okay, well, explain to me why.
Yes, because there's a big difference between a tort claim and a claim that's heard by a judge sitting without a jury. And I think that parties are entitled to have a jury with respect to their tort claims, and the claims here go far beyond what was done in the Superior Court in either the divorce case or in the probate case. The only claim that makes it appear similar is because of this Mobile Angel app, which my client developed. And the Mobile Angel app is a phone app that you can put on a cell phone, and it'll prevent texting while driving. So if you figure you got 100 million drivers that have cell phones and they pay $1 for that, that's $100 million in theory you could get for that. So at the time this complaint was drafted, I was not aware that there had been correspondence sent, and neither was Mr. Chalmers, frankly, that there had been correspondence sent from the Patent Office to either his lawyers or to his home where his wife was addressed to him. But the probate case was over, and the divorce case was over when that document was received.
And just so because if I remember right in going through all of this, that app was part of the Rule 69 agreement in the family case.
The app was, but the fact that nobody had done anything with it and had taken no action with it wasn't. The failure to disclose it is an issue. That's a breach of fiduciary duty, and the failure to try to address it wasn't. And even though the app itself was addressed as property in the agreement, it was never given to Mr. Chalmers. He doesn't have it, and the EVFS, the conservator, didn't give it to him, and nobody has done anything about getting him the things that he actually was supposed to have from the divorce either. And so the fact that
but go ahead, because I'm really trying to just, it seems to me that if I'm awarded property in a divorce action and I don't get it, then my remedy lies in the divorce action for a petition to enforce. Isn't that how it works?
Well, unless you have a conservator that has possession of it, and even though technically the conservatorship was supposed to terminate 9/18 of 2018, it didn't. The action technically did, but everything stayed in the Superior Court. And there were issues with respect to those things, but the bigger claim, Your Honor, isn't that. And the biggest claim that isn't addressed in any of that is the fact that all the fiduciaries knew about Dr. Barry's report. They all knew, because they all practice in this area of the law, they all knew there was a court investigator. And if you read the administrative rules about fiduciaries, for example, there are 9 provisions particularly that say that fiduciaries have an obligation to ask the court to terminate a conservatorship. And nobody did that. And that's not the only breach of fiduciary duty. That's a patent breach of fiduciary duty, Your Honor, with respect to that.
Is that a claim that can be raised within the confines of the probate action?
Not that I'm aware of, Your Honor.
I thought, did they hear any, is the probate court hearing anything on that issue?
Well, I'm not in that court anymore, Your Honor. I don't represent Mr. Chalmers in the probate court, but I don't think it is.
Was it an issue that you raised?
I don't think it is. Pardon?
It was not an issue that you raised?
Well, it was an issue that he raised.
He being you or he being your client?
Well, I think Mr. Chalmers raised that issue with respect to the fact that he shouldn't have to pay anybody any fees at least after that date, but
so it was being addressed by the probate court?
Well, the fact that they were paid money is being addressed. Whether he wins or not, who knows, but the breach of fiduciary duty, I think, is there in any event. And that isn't the only one. There are other similar arguments, too, that relate to the failure of the fiduciaries to do what they are court obligated to do. There's also claims about the fact that East Valley Fiduciary Services publicized information about my client's health, which is prohibited by HIPAA. That's not an issue for the probate court. That's a tort claim that he has. And
did he raise it in this case? Did he raise that
raised
claim?
in the civil case? Yes.
Okay.
That's mentioned in there. But I do think that to me, the most offensive of all the things that happened is that all of these people, for what one might reasonably think is their own personal ability to build the estate, none of them even asked for a hearing on this issue about terminating the conservatorship when my client asked them to in mid-October of 2017, which was before they had the Rule 69 meeting or the settlement meeting with Judge Budoff. And some of the issues with respect to that, Your Honor, there are other claims that Mr. Chalmers makes here that weren't addressed either in the divorce case or not. He had issues that because they wanted to give his wife some of his sole and separate property, over $100,000. But Your Honor, he was a protected person at the point this deal was done. I'll be the first to tell you. I have issues with the Court of Appeals saying in the divorce opinion that Mr. Chalmers was on notice that a motion had already been filed to have a permanent guardianship or conservatorship. He was there being represented by everybody else. He had no authority to represent himself. And he was made to sign the Rule 69 agreement. And the Court of Appeals in the other case held that against him. And this isn't about that. But it is about the fact that you can't have it both ways. You can't say that he's disabled and needs a conservator, and yet he's able enough to approve an agreement and be held bound by it and then be sanctioned for doing so. It seems to me that's where were his lawyers protecting him? Where were they? And when you look at the fact of the tax consequences weren't addressed. They were mentioned, but they weren't addressed in the Superior Court. Nobody told the court, for example, at the time the fiduciaries got permission to liquidate $284,000 of tax-deferred assets, nobody told the court what the tax consequences were going to be from that. And those tax consequences forced my client into bankruptcy. And that's an element of damage that the Court of Appeals can't deal with. Or not the Court of Appeals, but the probate court can't deal with that. So that's another claim that my client has. But I think all the claims we have, the only one that I agree, if somebody had talked to me about this before we got to the motions for judgment on the pleading stage, and keep in mind, I mentioned in my briefing, I filed the first amended complaint September 30, and on October 15th or 16th, Mr. Chalmers filed bankruptcy because of this tax issue, for which I got blamed by Judge Marcoy. It's not my fault. I wasn't his bankruptcy lawyer. And later on, his bankruptcy lawyer asked me to do a motion to remove the two cases that divorced the remaining issues about the estate and the tort case to bankruptcy court. I did that. And the court asked for briefing argument on it, as I say in my brief, and concluded that there was a probate exception that I didn't know anything about before the court mentioned it in court, and made a discretionary decision to remand them both to the Superior Court. Didn't impose any sanctions, didn't find anything inappropriate being done, just made that order. And now we have a judgment against me for $123,000 and another one for $29,000 by Judge Duncan, saying that somehow I should have known that my client had no rights and it had all been gone in the divorce and in the probate case. In neither of which forms would it be appropriate to bring a tort case. And my client's tort claims are different than the claims that were adjudicated. They were talking about dividing property and whether and how much the court was going to pay the lawyers and everybody else. That's what the probate court was about. There were no claims brought before the probate ended, 9/18 of 2018, and at all times he had appointed counsel. And so I don't know why that should bind him and say that somehow he's precluded because of abatement, because the claims that I have in this complaint. I agree there are some similarities to things that are being, where there are claims being made, but I don't agree by any means that they're the same thing. Not at all. And I think my client's entitled to a jury verdict with respect to that, and I think I would expect him to prevail. The jury to consider what happened here with all the professionals, all of whom took better care of themselves than they did of him, Your Honor.
Mr. Cook, one last question I have for you is, assuming that these claims that you're talking about arise only once the probate matter has concluded, is that when the statute of limitation would start to run for you to file a civil complaint if they aren't addressed in the probate matter?
Well, I would tell you, Your Honor, if my client came to me the first time and said that the conservatorship ended in September of 2018 and I got an order from the court in March or April of 2022, has my statute of limitations run, I would make the argument that it hadn't. But I think it's complicated by the fact that there's a court order terminating the conservatorship on September 18th of 2018. And the problem is, if you guess that it's not terminated, then you run the risk of giving up your case, and you never know what a judge is going to do with that. So out of an excess of caution, I thought he was better off filing within the 2-year statute time from September 18th, and he did. He filed the original complaint timely and amended it on September 30th. But I don't know the answer to that question on the facts of this case, because so much has happened. For example, you could say anything that relates at all to divorce, you should have filed 2 years after the Court of Appeals rendered its decision. You could say that. And because I've been shocked at some of the things that seem to be appealing, I mean, one of the big issues I have here is the judgment that was entered the first time that we appealed on January 8th. And that was a Rule 54B judgment, is what it said. And it said denied fees to EVFS. And then EVFS and Sharber submitted their own stipulation, called it a stipulation to amend or whatever, without telling the court. Everybody was given. I mean, it says it's only the two of them, but the very next day the judge entered an amended judgment, changing the judgment, and but again, denying EVS any fees and costs. There's 2 judgments where EVFS was denied any fees and costs, and I don't think it granted fees to Sharber in that one either. You can look at them. I have them in my brief and in the appendices. And so it was long after the time to appeal. After I filed a notice of appeal, nobody cross-appealed, nobody filed their own appeal. And it was after that that all this other stuff happened. And I think that first judgment was binding on the defendants, the way it was done. And they didn't take any action to do anything about it until after the time for appeal had run. And after the time for filing a cross-appeal. So no time extending motion, no notice of appeal, no notice of cross-appeal. And then all this other stuff happened. The other thing is, I think that you can't say that the case should be abated because the probate case wasn't yet concluded without also giving my client leave to amend and refile.
Did you ask for leave to amend below?
Pardon?
Did you ask for leave to amend below?
I didn't ask for leave to amend when the briefing was done. I did say that to the court, and I told them I could amend. I think I said that to the court, but I also,
Where is that? Would that be in the record? If
you know, Your Honor, I can't tell you as we speak.
Okay.
I can't read well enough to read my writing, or I would. But I believe that's, I don't think I asked for it before the court made its April ruling. But I did object to dismissing with prejudice on the grounds that I think my client's permitted to bring his claims in any event. But I don't think the abatement really applies the way things happened in this case, Your Honor. It's a hard question, but I don't know. I admit I don't know. I'd like to save my last 12 seconds, if I may.
All right, you may. Counsel for Appellees.
Thank you, Your Honor. May it please the court. My name is Mark Dangerfield. I'm appearing on behalf of the East Valley Fiduciary Services and the EVFS individual defendants. With me at the table are Rob Zelms, who represents the Sharber defendants, and also Kelly Jankaitis, who represents the Doyle defendants. We have conferred among ourselves, and since many of our issues are similar or overlap, I'll be addressing, taking most of the time. It may be that they'll want to make a few remarks, and if so, I'll give them some time at the end. Let me start where Mr. Cook ended up, I guess, with the issue of the two judgments that were entered before the, quote, final corrected, close quote, judgment was entered. Mr. Cook, of course, I understand why he would like the first judgment to stand, because it doesn't award any fees. But the fact is that those two judgments, as Judge Duncan specifically found, she entered them by mistake. They were not considered judgments, they were goofs. And Rule 60A of the Rules of Civil Procedure specifically says that a court, quote, must correct a judgment that is entered by mistake. And the rule also says that, by the way, if the judgment happens to be on appeal at the time the mistake is discovered, then you need the leave of court to correct it and modify it. So we followed that precisely. We filed a motion to suspend the appeal and to revest jurisdiction in the trial court. This court granted that motion. And in granting the motion, the court authorized the trial court to, quote, correct the judgment being appealed and to resolve issues pertaining to the awards of attorney's fees and costs. And that's what Judge Duncan did. She corrected it. She awarded fees, attorney's fees under ARS 12349 to both the Sharber defendants and the EVFS defendants. And so all of that was done properly. Mr. Cook complains that we didn't appeal from the initial January or December 22nd, 2020 judgment, which denied our request for fees. And that's right, we didn't, because we won on every other point. And as the court is well aware, it's very difficult to overturn a discretionary decision by a judge denying attorney's fees under Rule 12349. So that would be a normal course of not appealing that. Had we known it was entered by mistake, of course, it would have been a different issue. But in any event, the corrected final judgment entered in April of 2021 is the judgment that applies here, and it applies legitimately. The other two judgments, they were entered by mistake. There's no way to debate that, because that's what the judge said, that she entered them by mistake. So those attorney fee awards stand, and they're part of the judgment. And we ask that those be affirmed as part of this. Let me move now, though, to the I'll call it the merits of his major claims and the issue of abatement and claim preclusion. Because, Judge McMurray, you had it accurate in your very first comment that all of these claims that he's made in the lawsuit either were resolved or could have been resolved in the family court judgment, or were being considered in the probate court, and therefore needed to be abated. The best evidence of that is this court's decision on appeal in the family court case.
That's the 2018 matter?
Yeah, that's the 2018 memorandum decision. And when you look at that, the court makes several findings that relate specifically to the same type of allegations he's making right now in this case. I should say, my client, EVFS, was an appellee in that, and the court specifically mentions it. So here's in paragraph 11 of that opinion, for example, the court says that the husband, that's Mr. Chalmers, blamed EVFS for these issues. These issues meaning, as in the sentence before, that the husband disputed financial divisions and alleged that the wife had failed to disclose some personal property in her possession. And the husband blamed my client for that, EVFS. Mr. Chalmers also, as your opinion goes on to say, that Mr. Chalmers also claimed that, quote, contested facts showed that EVFS failed to properly investigate his claims that the wife committed waste. The court winds up affirming the Rule 69 agreement, finding it fair and equitable, which is exactly the same conclusion that the family court arrived at. That is, the judge in that case found it fair and equitable. And when you actually read the Rule 69 agreement, makes it pretty plain that Mr. Chalmers thought that that agreement was fair and equitable as well, because he signs it, and the agreement itself expresses that those who sign this are doing it knowingly, voluntarily, with the understanding that it's going to bind them. Now, you heard Mr. Cook say, well, but he was subject to pressure from his conservator, EVFS, and he had court-appointed lawyers, and sort of overborne his will is sort of the flavor. He doesn't quite say it that way. But there's no facts to support that. He signed the agreement. And keep in mind that Mr. Chalmers had a conservator. A conservator is there to guard the money. He doesn't have a guardian, which is a guardian is typically appointed when somebody might not be able to think clearly or might not be able to manage to make decisions. But he doesn't have a guardian. And in fact, Mr. Chalmers will be the first one to say, as in fact Mr. Cook said to you, that he didn't need a guardian or a conservator. In his view, Mr. Chalmers was fine. And yet on the other hand, he wants to say, oh, Mr. Chalmers wasn't competent to sign that Rule 69 agreement. But he did sign it. And in the family court appeal, he made the same excuse you just heard Mr. Cook say, which was that, oh, well, he was kind of forced to sign it upon threat that they would try and get a permanent conservator appointed. And in your memorandum opinion, you addressed that too, and you rejected that argument. So all of those things have been covered in everything related to that Rule 69 agreement. What was in it, what wasn't in it, how it was carried out, was made in the family court and addressed in that family court. And yet when we got the complaint, in this case, there we go, right back to the Rule 69 agreement. The complaint alleges that, I'm looking at paragraph 44 of the first amended complaint, where it says at the time of the settlement conference, the Rule 69 settlement conference, the plaintiff objected to some of the provisions of the proposed settlement agreement, and his principal and most financially significant objections related to, and he lists several items, but the first of those is this cell phone app that Mr. Cook was talking about. He says he objected to it because that wasn't sufficiently addressed in there. Well, it's too late at this point to raise that issue. That claim is precluded by the family court decision approving it, and this court, the Court of Appeals, affirmation of that. And I believe we put this in the brief, but the Court of Appeals didn't just affirm the family court, it awarded attorney's fees to EVFS for having to defend that appeal. And then they took another step, they appealed it to the Supreme Court, or they filed a petition for a review. That court denied the petition, but again awarded attorney's fees. So the issue of courts awarding attorney's fees against Mr. Chalmers for positions he takes, this isn't the first time that's happened.
So counsel, let me ask you this, as far as this allocation of the app, the mobile angel app, is the family law case the exclusive venue that Mr. Chalmers had to pursue that once it was mentioned there and brought up, or did he have an action in civil court in any way, fraud, anything like that, that he could have pursued?
None that I'm aware of, Your Honor, because the issue was the Rule 69 agreement has a provision relating to his personal computer and information on that computer. And now he's saying that in this complaint, he's saying he actually objected to the Rule 69 agreement not having put more stuff in about that. And so he made that argument.
So
he made that argument to
wouldn't
the
his
family.
care be going back to the superior court in family at least and saying, hey, there's some unallocated asset that you need to deal with?
So he did, following the Rule 60, yes, the answer is yes. Following the Rule 69 agreement, he did object. Even though he signed it, he immediately objected to it and said that there were various problems with it, and they wanted an evidentiary hearing on it. The family court considered that and denied it. So he had an opportunity. And even aside from that, Your Honor, the reality is, as a matter of law, that there is no patent like he claims. I'm reading right from his complaint. Plaintiff formerly held the patent for a cell phone application. Now that statement's false. And it's not just because I'm saying it's false, it's because you could look up in the U.S. Patent Office website, which we did. It's public knowledge, public information, and you can read, in fact we attached it as an appendix to our brief, you can read where the USPTO denied his patent. At least it was a preliminary denial and it invited him to give some more information. He never did. And now he wants to claim that, blame EVFS for that. As part of his complaint, he says, well, EVFS, they had a letter from the patent office that said I had not done what I was supposed to have done. They should have turned it over to me. That's the claim in his complaint. But again, and we've attached this to our appendix as well, the EVFS got a copy of that letter from Mr. Chalmers himself. So there's just lots of stuff in here that doesn't make sense. There is no cause of action here. Let me turn to the abatement issue and the role of the probate court now. We've talked sort of about the family court. Let's go to the probate court. A lot of Mr. Chalmers' claims, as articulated by Mr. Cook, relate to his view that the fiduciaries in the probate action spent a lot of money, were paid a lot of money, and they just screwed up. And therefore, he wants some of that money back. Well, the issues about, let's start with the money that the fiduciaries received in the probate action. The probate court reviewed Rule 33 applications by the professionals for fees and approved or didn't approve those applications. That's all in the probate court. Now Mr. Cook wants to revisit those in this court. And in fact, the probate court is still working on those. Judge McMurdy, you referred to the Court of Appeals decision from another panel that partly affirmed and partly remanded. And what it affirmed, let's talk about that for just a minute. Mr. Cook made a lot of the same claims he's making here in the probate case. And when I say Mr. Cook, I don't mean another court-appointed lawyer. I mean Mr. Cook himself. He wants to convey the illusion that Mr. Chalmers never really had good counsel in the probate case because it was court-appointed counsel. Now, of course, the fact that someone's court-appointed doesn't mean he wouldn't be good counsel, but that's the implication he wants to give. But Mr. Cook himself took over as counsel. And we've indicated in our brief a few of the documents that Mr. Cook filed where he makes claims that are essentially identical to the claims he's making here. I'll give you a couple
You mean
of...
claims in the probate matter
Correct.
that are identical?
Correct.
If I could ask you,
Yeah, please.
just, is the probate matter, I'm trying to make sure I can articulate this correctly. If your claim is a breach of fiduciary duty arising out of a probate case, is that something that has to be litigated in the probate case, or is that a separate civil action after the probate matter has concluded?
Well, I guess there's maybe two parts to that, Judge.
Okay.
And it might depend on the facts. In the facts here, you in the probate court, Mr. Chalmers certainly could raise the issue that in fact, he did raise the issues, such as that one of the issues he raised and talked about here is what he said was the failure of the lawyers and fiduciaries to advise the probate court that there's going to be tax consequences to generating funds by selling some of his retirement assets. So that's certainly an issue he could raise to the probate court. The probate court could have taken measures to address that. And as a matter of fact, he did raise it in the probate court. So I'm now holding an objection to petition for approval of final annual account filed by Mr. Cook on Mr. Chalmers' behalf in the probate matter. And it's attached to our appendix. And so this is what...
Just because it's gotten a little confusing, what's the date of that one?
Yeah, the date is this, March 14, 2019. It's IR 40 and AP, it's appendix page 66 in our appendix. And he says here that there's been malfeasance by the fiduciaries. And part of that malfeasance is that, I'll just read this sentence. The fiduciary, East Valley Fiduciary Services and its employees and owners, malfeasance is evident because the fiduciary asked the court to liquidate the ward's retirement accounts without advising the court of the substantial detrimental tax consequences for doing so. That's exactly the same claim he's now making in this case. He made it in that case, and it was denied. The probate judge, in its final order, denied all of Mr. Chalmers' claims, except that, as you know, I know you've read the briefs in the record, except that the probate judge denied the Rule 33, the pending Rule 33 fee applications of the fiduciaries. It was their second or third, depending on the fiduciary. And he denied that, finding that they had been paid enough. But all the other motions and issues that were being sought in the probate court, he denied. One of the big ones was Mr. Chalmers' claims that EVFS, our client, had botched the final accounting. And that related to the money that was liquidated from the ward's retirement accounts. So those issues were resolved. Now, maybe if there were some, I'm having a hard time imagining it, Judge, but maybe there might be some separate issue. But Mr. Cook complains that there were no tort claims, but the answer to that is, well, was right in your question, which is, if the basis for a tort claim is resolved, then that doesn't matter. You can't have a tort claim unless you have some underlying basis. So I'm down to 30 seconds. Would any of my other counsel like to say anything before we end here? All right. And
Counsel, I just had a quick record question.
Yeah, please
Did he seek leave to amend his first amended complaint in this matter below?
No, if you read his brief in response to our motion to dismiss, which was granted, he does not ask for leave to amend.
But he said today that he'd made an oral motion. Do you recall that at all?
I do not.
All right.
I don't one way or the other. But
All right, thank you.
if there's no more questions, I'll sit down.
All right, thank you very much. Mr. Cook, you have 9 seconds.
I've asked for an extra minute. May I have that, Your Honor?
Well, since we didn't give the other side a minute, I'm going to deny your request, but you have some.
Very well.
Go ahead, make a statement.
Yes. I asked the court to enter the order without prejudice so I could bring the claim based upon what the court said, Your Honor, and what they're saying about me bringing tort claims in the probate course is incorrect. I didn't bring tort claims. We asked the court to limit how much they're going to pay on the pending applications because of that, and it was the court accountant who made all the objections. We asked for an expert to address that, and the court denied it. So that's what ended up happening. The court refused us that.
All right, thank you very much.
Thank
The matter
you.
is deemed submitted. We'll issue a decision in due course, and with that, we stand in recess.